doing. All right, so starting 2004, July, question 1. Call the question. May Dan being the defendant, properly convicted of either first or second degree murder? And if so, on what theory or theories? The fact that they're using theory or theories lets me know that Dan did not himself do the killing. That means somebody else did, and we're trying to hook him to it. So that means there's the conspiracy theory, accomplice liability theory, and felony murder. And because they're talking about first and second degree, probably something about maybe felony murder, I would have to think. And we have Art and Bert, 4 different calls, 4 different situations. And you might be able to group these later, but we'll see. May Chuck probably be convicted of any crimes, and if so, what crimes? So what did Chuck do? Focus on Chuck's intent and his active intent for most crimes. And number 3, how should the court rule on Dan's motion to dismiss? And that's under the speedy trial rights. Now, most people don't know anything about speedy trial. And other than this 2004 essay, I've never seen them test speedy trial. So what happens when they give you something, and this will be the 1%er that I'm referring to, that you don't know? How do you figure it out? I'll show you how to answer the speedy trial question very simply. All right, let's take it from the top. August 1, 2002, so that was about 2 years ago. And for some reason, I quickly scanned down with the dates, because dates are very important. And I see, wow, we got the 3rd paragraph starts a year later, and there's a bunch of dates there, 2003, like, wow. This covers a period of, I'm sorry, not a year later, it's a day later on the 3rd paragraph. But I see the 2003, so it's like, okay, it's next year. So interesting that there's a time gap, a speedy trial. We'll see how that plays out. Dan, Art, and Bert enter into Vic's convenience store. Believe it or not, in criminal law, whenever they test conspiracy, you'll notice it'll be in the first or second sentence because they have everyone together. Now, how are they going to prove an agreement? I mean, nobody was there when the 3 of them agreed to rob the store. Well, the answer is most conspiracy, in fact, almost every single conspiracy, has to be proved by circumstantial evidence because they're clandestine in nature, which means they're secret. Like if Adrian and I were to agree with a crime and we're sitting there on the phone or we're in person and we're, the prosecution's not listening. They're not hearing what we're saying. But how do you prove the conspiracy? Well, the fact that the 3 of them entered the store at the exact same time, doing the exact same thing, and they came in the exact same car, you can infer the agreement. So somehow we're going to get to conspiracy. All right. I'm sorry, it's the death of Bert. I'm sorry, it's the death. It's not our first degree. It's Dan's the one who committed the crime. All right. So I assume both these guys are dead. It's Dan who did it. So as we know, they entered the convenience store. 3 walk in, 1 walks out. That's all we know. Dan and Art pointed guns at Vince as Bert removed the 750 from the cash register. All right, so we have a robbery. Now, why am I bringing that down when I'm only asking about first and second degree? Because here's the theory: conspiracy is a theory, and robbery is a felony, which I'm probably going to use for the felony murder. And I'm just writing things down as they happen. You can also get them for burglary, but I think robberies, either one. So there you go. You have them removing the money from the cash register. I don't think they're looking for a breakdown of robbery, but they pointed the guns, very similar to the last essay we just did. They're pointing the guns. They're using the force, the threats, the intimidation to get the money to permanently deprive. So robbery is just larceny plus assault or battery. As Dan, Art, and Bert were running towards Bert's car, Vince came out, and Vince V is always going to be the victim. They'll do that, make it easy for you. Came out of the store with a gun, called them to stop, and when they did not do so, he fired 1 shot at them. The shot hit and killed Art. So Art is now dead from that. So felony murder. Well, first degree, so the best way to look at murder, I'm going to put it right here for right now. So when you look at murder, let's make it real easy. We have act and intent. The act is killing a human being. So I'll put killing person, right? And the intent is malice aforethought. All right? And all that means is the prosecution gets 4 bites at the apple. So what are the 4 prompts? You have felony murder, you have premeditation and deliberation, then you have great bodily injury, and you have depraved heart murder. which is extremely reckless conduct. Okay. Now, most jurisdictions, they don't give you a statute here. If they did, you apply the statute. If on an MBE, they tell you that first degree murder is only premeditation and that all other murder is second degree, that means felony murder is second degree. But the statute will always apply if they give you one. You ignore everything you know if they give you a statute. And they do that quite often on the MBEs. Because remember, at common law, there were no degrees of murder. Everything was murder. Just probably your penalty different. Okay, so here's the thing. Felony murder is first in most jurisdictions, and the intent to kill, premeditation, and deliberation is also first. Grave bodily injury is second, depraved heart second. There you go. That's how you break up murder. And can anyone see what I'm writing on the board? Okay, clearly perfect. So now it's interesting. If you want to go to manslaughter, watch how this works. So for manslaughter, so premeditation, and this is the intent to kill, obviously. So when you have the intent to kill, if you were heated, the heat of passion, you can get it down to voluntary manslaughter. So all voluntary manslaughter is, you clearly intended to kill the person. And whenever I think of voluntary manslaughter, the simplest, easiest way to think about it is spouse in bed, because that's the most classic example. All right? You're enraged, you point a gun, you fire, you kill your wife or your husband. Not the third party. They're just, unless they knew, then I kill them both. My sentences will probably run concurrent, so I get 2 for 1. That's probably a good deal. Okay. If you can get your sentences to run concurrent, that's awesome, which means if I'm serving 8 years for one, 8 years for the other, I'm only serving a total of 8 years. If the sentences run consecutively, I'm serving 16, which is not good. Okay. Felony murder. Well, what's the little brother of felony murder? Misdemeanor manslaughter. And that is involuntary manslaughter. And depraved heart is second degree murder. Depraved heart is part of murder. And then this is criminal negligence, which is involuntary manslaughter. So you know how they're just variations of each other. Little brother, big brother. That's it. I'm sorry it's down so low. Hopefully everyone can see the screen okay. So for felony murder, it's a felony committed and somebody dies. Misdemeanor manslaughter is you committing a misdemeanor and somebody dies. Premeditation, the intent to kill, first degree murder. But if you kill them when you're a little enraged and the average person would have been enraged, voluntary manslaughter. But remember, voluntary manslaughter is always an intentional killing. Always an intentional killing. And depraved heart. And what's the difference between depraved heart and criminal negligence? It's just a matter of degree. Well, how do we determine where that line is? Well, in general, they'll just say the most serious and just pick the most serious. But on an essay, how do you determine what the line is? Ask yourself the simple question, would you do that? Would you fire a gun into a crowded party just to keep them quiet? Well, if you say no, and reasonable people should say no, then somebody who does that is clearly acting extremely reckless. Would you drive 90 miles an hour in a 15-mile-an-hour zone? Most people would say no, that'd be extremely reckless, that's murder. Would you drive 5 to 10 miles over the speed limit, maybe while you're texting? I think most people say yes. Involuntary manslaughter doesn't rise to the degree of felony murder. All right, so that's all you gotta do is ask yourself that question. So now we're gonna talk this. So felony murder. Okay, well, it looks like we have a felony that was committed during the course of inherently dangerous felony. The only problem is the killing was by Vince. Under the majority agency theory, which is what they're getting at here, under the agency theory of felony murder, notice the word theory. Both of them call the question in here about conspiracy theory, agency theory, is the killing, in order to be found guilty of felony murder under the majority agency theory, the killing must have been done by a co-conspirator, co-felon, a co-defendant, however you want to say it. So if one of your boys, if one of the gang, if one of the people in your group committed the killing, you're on the hook. So if Dan had shot Vince, Art and Bert are on the hook. If Art had shot Vince, Dan and Bert are on the hook. And if Bert had shot Vince, Dan and Art are on the hook. If a clerk had shot at them, let's say a customer shoots at them, misses and hit Vince, they're not responsible because that customer is not part of the conspiracy, they're not part of a gang. There you go. That's all agency is. So agency here, no liability. But under like the minority proximate cause theory, that means everybody's, I mean, is it foreseeable that the clerk would come out and start shooting and like somebody would stop, somebody would resist? Absolutely. So under proximate cause, which is way broader, the answer is going to be yes. In fact, it's rare that the answer is not yes under proximate cause. What they're really looking for here is agency theory. There you go. And second-degree murder, probably not, because again, he didn't do the killing, and there's no way to get him for felony murder. So this is really, for second-degree murder, you talk about great bodily injury and depraved heart, but you didn't do the actual killing. So there's really not much here under second, because he didn't actually do the killing. Oh, it looks like Bert got away. So it looks like three men enter, 2 men come out. All right, and notice the first paragraph goes to call 1A. The next paragraph goes to 1B, and the last paragraph goes to 1B and to 2. And the last paragraph goes to call number 3. So the examiners do a very good job of laying this out and making it mini essays. So all it is one mini hypo. Look at 1A, first paragraph. These two, second paragraph, last paragraph. That's all it is. Dan and Bert drove to Chuck's house, where they decided to divide the $750. Now keep in mind what kind of people these are. $750 to take a life, or at least it's unbelievable. And then they're gonna. And there's 3 of them. They got to split it. I mean, this isn't like a rock band where 4 of them have to split it. Like Jesus, $750. When Chuck said he would tell the police about the robbery, so now, what's Chuck doing? I will tell on you if you don't give me more money. Yeah, they should have wiped out his Chuck. Because he's probably a crook like them. No one's going to come looking for him, and he can hide out in his house. So what crime is that? When Chuck said, "I'll tell the police about the robbery," he's extorting them. It's extortion. So here we're going to go to Chuck's crimes. We'll put the little thing here. Extortion, also known as blackmail. Now they technically have a little bit of like a difference. I think blackmail is for public officials back in the day, but really they're really part of one crime. So whether you say blackmail or extortion, it's the same thing. And in order to extort somebody, you have to know that they did it. Well, I'm sorry. No, you just have to extort them. You just have to, I won't tell on you if you do this. If they're not giving part of the money. So Bert gave him $150. Bert gave him $150 of the stolen money. Does he know the money's stolen? Yeah, because he said, "I'll tell you about the robbery." Receiving stolen property. Like, there are 3 of them. Okay. One last thing, it's kind of hard to get from the facts. And most people only get 2 out of 3. It's really hard to get all 3. Chuck has one more crime. And that is, does he know that a felony's been committed? Yeah, clearly, because he's going to tell him about the robbery. And he's letting these guys hide out at his house, harboring a fugitive. So either harboring a fugitive, which you might know better as accessory after the fact, because he's getting them to escape or at least be prevented or hindering prosecution or their ability to be punished. So harboring a fugitive, which means also accessory after the fact. I'll be honest with you, the first time I did this essay, I did not catch all 3. I caught the extortion because I do that quite often, and the receiving stolen property, but I didn't see the accessory after the fact. Okay, moving on. So that's all Chuck's crimes. Let's see here. So they gave him $150. So these guys got to split up $600. Dan asked Bert for $300 of the remaining $600. Bert claimed he should get $500 because his car had been used in the robbery. That's real smart. Dan became enraged. Shot and killed Bert. So here, did he intend to kill him? So we have here the intent to kill, which generally would be first-degree murder. Believe it or not, I'm not going to. I shouldn't even say this. Some jurisdictions will, because whether or not you actually premeditate and deliberate, like, I mean, he really didn't do so in a common, cold manner, but it's discussion for the other day. In fact, not any day during this course. So, intent to kill is generally first-degree murder. Question is, should it be reduced to voluntary manslaughter? Well, let me ask you this. Would a reasonable person shoot someone over $200? There's your answer. And you don't have the same conclusion on it, so no, you're not gonna use that. Remember, when you talk about voluntary manslaughter, subjective and objective, hot and cold, just hot and cold. Was Dan enraged? Was he hot? Was he heated? Yes. Would the average person may have been heated if somebody's trying to jip him on a couple $100? All right, let's just keep it. Did Dan cool down? No, he didn't cool down. Would the average person actually, no, I think the average person probably wouldn't have done that, so I missed it. So the hot and cold, I don't think the average person would have gotten this enraged. So whether or not they had time to cool, so it's hot and cold, so it's just subjective and objective. Would the average person have been upset? Was the defendant upset? Would the average person have cooled down? Did the defendant have time to cool down? And the element that they almost always get at is, did the reasonable person have a chance to cool? That's the element they have. Because clearly the defendant didn't get a chance to cool. One of the ways they do it on the exam is they'll have a guy walks in, finds his wife in bed, and his gun's out in his car, and it takes him a while to get to his car, whatever the case is. They make it seem like, like a good 5 to 10 minutes. And he had to load the gun, and then he had to go back in the house, and then he fired the shot. And well, did he have enough time to cool? Well, clearly he was still heated. Would the average person still be heated? And that's a discussion that could be open for interpretation. I personally would have been. Some people would have been like, no, I would have had a chance to as I'm loading a gun, going, what am I doing? You know what I mean? So I mean that's the whole. What would a reasonable person do? I don't know. Who here would have cooled? Who here would you catch your spouse? Raise your hand if you would have cooled. Good. Okay.
I'm gonna kill somebody.
So anyways, moving on. And second degree, I mean, some jurisdictions do find the intent to kill under such small circumstances. You might not find him guilty of voluntary manslaughter, might find him guilty of second degree. But here, I mean, the only thing you'd probably get him for is extremely reckless. You know what I mean? That even doing something like this, but even so, that's more of an implied, not express. What they mean by implied malice. So the only express malice murder is the actual specific intent to kill, which is this is the express malice. The rest of them are implied, because in all three of these situations, you never intended to kill anybody. During the felony murder, you didn't intend to kill anybody. It was an accidental killing. If you intended to kill them, they would just show intent to kill. Great bodily injury, you didn't intend to kill them. You only intended to cause them great bodily harm, like you hit him with a crowbar in the leg, which is a very common fact pattern on the MBE. And depraved heart, you were extremely reckless. You didn't mean to kill anyone. You're just not driving 90 and a kid got in the street. Okay. Dan became enraged, shot and killed Bird. He then decided to take all the remaining 600 for himself and remove the money from Bird's pocket. Interesting. One selected answer I think did discuss it, one didn't, but I'm kind of curious to know, were the examiners trying to get at felony murder for robbery? But the thing is, he took the money after, but it's immediately after, so that would still be part of the same continuous transaction. I mean, because you can steal money from a dead person. You can't, by the way. Because that money belongs to their estate. That money belongs to their heirs. So you're actually stealing from somebody. So whether felony murder, I don't think they were looking for felony murder. Again, only one answer discussed it, and you already discussed it here. I don't think they were getting at it there, but I just found that curious. Okay, so there goes calls 1B, and there's 2. Now we're moving on to the speedy trial. For those of you who don't know anything about speedy trial, there's 4 factors in it. And I'm going to tell you a little bit about the case, Barker versus Wingo, that came up with the factors. So Dan was arrested August 2002, so he got arrested the next day. Formally charged, 6th Amendment right to counsel attached, with murder and robbery, so they give you the underlying felony, so that's why robbery's here. He was arraigned and denied bail. Okay, so being denied bail is not only a violation, or could be a violation of the 8th Amendment, cruel and unusual punishment, but because they're taking away, you've heard this before, life, liberty, or property under the Due Process Clause of the 14th Amendment. So denying somebody bail also has 14th Amendment implications. Why do I say that? I've seen an MBE question when they denied a guy bail, and like, what constitutional arguments can he bring? One said 8th Amendment only, 8th and 14th, 14th only, or none. The answer is 8th and 14th, because you're depriving them of their life, their liberty. You're restraining them. without, because he hasn't been found guilty yet. Remember, he's presumed innocent. I mean, think about poor OJ. Poor OJ didn't even do it, and he sat in jail for 2 years. For those who know anything about the OJ case, he did do it. They just found him not guilty. Poor Ron. I mean, Nicole, I get. Ron, I would have given him a pass. So unless he was sleeping there, then he got a 2. But anyways, subsequently, the court denied his request and set trial for October. Okay, so the thing is, for speedy trial, you have to assert your right to a speedy trial. And by Dan, so you have to assert your right to the trial. Okay, and also the amount of time it takes, and we'll see how that all factors in. The court denied his request that the trial be set. Okay, so he's denied bail and scheduled the trial to begin. Subsequently, the court denied Dan's request that the trial be set. So he's asking for a speedy trial. He's saying, hey, look, let's get this thing done and over with. They said, no, we're going to do it on January 5th. So they kind of denied his right. On January 3rd, the court granted over defendant's objection. So again, he's asserting his right. The prosecution requested to continue the trial to September, which is now 9 more months he's going to be sitting there, because the prosecution had scheduled a vacation cruise, a statewide meeting of prosecuting attorneys, and several legal education courses. Okay, so one of the factors is right there. What's the reason for the delays? The reason for the delays by the prosecutor. Like, why are they delaying? So the amount of time you're going to be cooked in there, stuck in there as an innocent man, allegedly. Whether you asserted your rights, the reason for the delays. Again, if you don't know what these factors, they're actually right here. They give you it. They give you all the law there. So you might not remember everything, but you can kind of like pick it out of what they're actually saying. Because okay, on September 2nd, 2003, Dan moved to dismiss the charges. On the last one is asserting your rights, the time it took, the reason for delay, and the prejudice that it causes you. And what's the prejudice? Well, that he's locked up. That's it. Because if you're out on bail, you don't really have it doesn't really matter. You're out on bail, you're living your life, although it's still like mentally like tough, but you're not being prejudiced by being locked up in a cage like he has been for the last year. Again, he hasn't been found guilty. So on September 2nd, Dan moved to dismiss the charges for violation of the speedy right. Now here's the thing: how's the court really going to rule? Because this is murder, they're going to deny it. They're going to find a reason to deny it. But anyways, those are the factors. I mean, he asserted his right. He's got prejudice because he's been denied bail. The time has been over a year, and the prosecution kind of gave BS reasons for the delay. Now I'm going to tell you about the case Barker versus Wingo, and I have seen speedy rights on the MBEs. One is, when does it attach? It attaches when you get arrested. So if they're just in, so I've seen that tested, and the other situation where I've seen it tested is where I think they found the guy's DNA. They were investigating him, like they questioned him, and for 3 years they were trying to gather evidence to bring charges. 3 years later, they bring charges. He asserted his right to a speedy trial, or they said, hey, you guys delayed so much by gathering all the evidence that you violated my rights. The answer is no, they hadn't even arrested him yet. Like, he had never been arrested. So, and they'll do that. They'll spend years gathering evidence. The only argument you can really make is statute of limitations. That's the only argument you can make. By the way, in this Barker versus Ringo case, let me tell you what happened. This guy was sitting in jail for about 7 or 8 years. The case had never come to trial. All right. And even though he'd been in jail for 8 years, they still denied his speedy trial rights. Why? And here's why. Because when it was set for trial, he kept changing counsel. So he kept delaying the proceedings, kept filing motion after motion to keep delaying the proceedings. And even though he was denied bail and he sat in jail, the reason why it took 8 years is because there was one key eyewitness against him. And it took her 8 years to die. He was just waiting for her to die. And the second she died, he goes, let's go to trial. And so he asserted his rights, and they're like, no, no, no. What were the reasons for the delay? The reason for the delay was you kept delaying it because you wanted the only witness to die. The time, yeah, it was 8 years, but that's your decision. You never asserted your right to a speedy trial. Not once in those 8 years did you say, let's go to trial. In fact, you were trying to avoid it. And prejudice, you benefit from the delay. You didn't want prejudiced by it. So there you go. All right, and that's the conclusion of 2004 July, question 1. All right, let's open it up to questions. Go ahead, Ethan, if you want, you can turn the recording off now. I don't know if I should say or do anything. All right, Jeff, what do you got, bud?
Are there, excuse me, are there two issues of or two grounds for his motion to dismiss because of the first 6 month delay and then the second 9 month? And would you address them separately, or is it one big 15-month delay speedy trial?
Probably one, yeah, the whole big ball of yarn, you know. I did write a model answer on this. You could check that out as well
Yep.
on how that's put together. But I just go through the elements that the prejudice, and there's really no conclusion. But I'll tell you what's really going to happen in real life. There's no fucking way the judge let this guy out. There's no way he's like, oh yeah, well, you know, you're a murderer. You are a cold-blooded killer twice. Or I mean, you robbed a store. You got one of your co-felons killed. You stuck a gun in a guy's face, and then you shot your buddy. Dude, you're not getting out. So remember I said, like, they're going to, and this is why I don't like constitutional law, because when they're supposed to rely on precedent, if they want that decision, like, well, that's what precedent is, we have to follow it, stare decisis. What if they don't like it? They're like, oh, well, that was decided wrong 30 years ago, so we're going to overturn it. Huh? So you can just make up so you can tell me when it was decided wrong, but you can say, like, well, we have to skip by it. Sorry, we can do, our hands are tied. It's just, call what it is. It's bullshit. You know? I hate when things get political. Things should be we should have neutral people. It's not a perfect world, will never be. Okay, question someone else. So Jeff, hopefully that answered your question. If I did. Olivier.
What is the reasonable amount of time?
What's reasonable to you? What's reasonable to me? I mean, there you go. I mean, I think 8 years is a little unreasonable. Year or two? I don't know if OJ asserted his right to a speedy trial. So you guys all know OJ was in jail. Like, they denied him bail. Probably because he was going to jump. I mean, he tried jumping, before, the L. Cowling's car ride. If you don't know anything about the OJ case, it's quite fascinating. And just so you know, do you know why OJ got off? For those of you that know that, and anything about history in LA, that was direct payback for Rodney King. That was strictly payback for Rodney King. For those of you who don't know, Rodney King, before a video camera, I think in 1993, what was Rodney King in 1993? A bunch of officers, and they were white officers, he was a black man. Now, what Rodney King did was not, I mean, he was on PCP, he was driving recklessly through neighborhoods, he endangered all their lives, he put the lives of innocent people, and he had a rap sheet 2 miles long. So he was no saint, and the officers knew that. But anyways, somebody filmed with one of those like big video cameras, because that's what they used to have back in those days. And the officers were beating him with batons. Little, borderline excessive. I would say it definitely was excessive. But okay. And so these 4 officers went to trial, criminal trial. And on April 29th, 1992, they were found not guilty. Not guilty. Well, the riots broke out that night. So they were found not guilty, I think, around like between 11 a.m. and 2 p.m. I forget what time it was. And then around 6:15 p.m., Reginald Denny's getting pulled out of his car. You don't know who Reginald Denny is? Google that one. Google Reginald Denny, watch the video. It's one of the most disgusting things you'll see. Beat this guy with a brick. He had nothing to do with anything, pulled him out of his car, and he's bleeding in the street and just keep kicking him and no one's helping. He ended up living, which is crazy. And you know what the funniest thing is? They only did that because he was white. He was married to a black woman. You want to hear the craziest thing? I drove through the intersection 14 minutes before they pulled Reginald Denny out. Yeah, I was in Inglewood that day. Crazy. I watched the riots happening. Yeah, it was nuts. So anyway, that's how I know about the history of what really happened. I don't know if you see that in a history book or whatever the case is, but and the jurors were pulled years later and they said, this is payback for us, because the 4 white cops got exonerated. They were all found not guilty. Well, this is payback for Rodney. So OJ was just like, he was the perfect defendant on the perfect time. And there's no way they were going to find him guilty. And they had all the overwhelming evidence. Like the Saturday Night Live, Norm Macdonald on Saturday Night Live for months and months and months would just do sketches of like, he's like, the Pope's got a new book out which talks about the secular world for the Catholic the Catholic, church, with these new times. The book is titled, of course OJ did it. Like he would just have these jokes like, and this was before he was convicted. So anyways, and then after OJ got convicted, his next segment was, it's now official, murder is legal in California. So anyways, that's that. All right, any questions about this essay or any other thing we got going on here? It's amazing how fast we get through the essays when it's just me. Come on. So who here knew anything about speedy trial? Yeah, I barely knew it. But you see how you kind of look at the facts? Because they have to give you the factors and they are factors. So the difference between factors and elements. And let me explain what those are. So we take a thing like negligence. There's duty, breach, causation, and damages, right? Those are elements. So you have to prove every element beyond a reasonable doubt. Like, for example, for burglary, I have to prove beyond a reasonable doubt that you broke into my house. I have to prove beyond a reasonable doubt that you entered my house. The prosecution broke, someone's house. They have to prove beyond a reasonable doubt that it was someone else's house. They have to prove beyond a reasonable doubt that you had the intent to commit it on the way in. Okay. So even on the negligence, duty, breach, causation, you have to prove those elements by a preponderance of the elements. Well, how do you prove whether or not somebody breached their duty of care? Whether or not they acted reasonably in the situation? Well, there's factors to determine whether or not they act reasonable. And those factors will add up to determine whether or not the element is met. So if the factors weigh, so what's reasonable? Like if you find somebody to be unreasonable based on all the factors, like the time, the situation, the circumstance, the cost, and like weighing everything together, the scale tilts like this, all right, then it was unreasonable, that element's met. We still have to prove causation and damages. See how that works? So elements are required to be met. Factors are used to prove a particular element.
For the asserting you're right,
Asserting you're right.
does it have to be affirmative? Like
You have to make a motion blank.
Okay, so like for here where he made the motion to dismiss further.
Well, he made it way after. What he did was, he requested the trial be set for October 15th. So he's requesting a trial now, and they denied it. So he's asserted his right by saying that. And again, over Dan's objection on January 3rd, he didn't want to continue. He's objecting to continue. So he's asserting his right. He's saying, look, I don't want to continue it. I want to do it now. Let's go. So that's asserting the right.
Thank you.
Jason, I had a question.
Armand
Armand.
with MARMAN, right?
Yes. Jason, my question was for the first call for Art's murder by Vince. Do we have to discuss anything relating to the red line rule that the co-felons are not responsible for the death?
No, because I've got agency and proximate cause. I mean, you really don't need to discuss red line. I mean, there were a series of 3 Pennsylvania cases like in the 50s. And I forget how they all differ, but other than like one selected answer that brought it up once, I try not to touch on it. So red line just means like if one of your co-conspirators gets killed, right?
Right.
But who did the killing of the co-conspirator? So that's there could be I know I put together the chart that does that, but I mean, it rarely applies, because who would have to have killed them?
Isn't it the police?
Or like, let's say, it pretty much happened here. Like Vince killed Art, right? He shot and killed Art.
Yes.
So wouldn't that fall on the red line too? Look at red line. What's the other line say? So here's the thing, guys. Even I have to refer to
Art killed D2, D1 not guilty of felony murder.
criminal law.
Page 7 of
Thank you, Brandon. Page 7, everyone, of the criminal law outline. So here we go. All right, so if the clerk kills a customer, okay, that's agency, it's not guilty, because clerk is not. Yeah, but if one of your co-felons, one of your other defendants kills the clerk, clearly guilty of felony murder. And here, the situation we have here is the clerk killed one of the defendants. So you're not guilty under red line, you're also not guilty under these. Okay. Yeah. So yeah, that was the red line. That was red line situation, but it also falls in their
Agency.
agency theory will cover as well.
Okay. Thank you.
Yeah. Because whoever Now, here's what they do on the MBEs. Is they'll have situations where like three people are together. I remember this. It was a guy, his buddy, and a girl. And they went to go rob a drug dealer. And in the process of robbing the drug dealer, one of them shot and killed the drug dealer, whatever. On their way coming home, and it was a guy, his girlfriend, and his friend. And on the way walking home, the guy learned or knew or somehow found out that his girlfriend was sleeping with his friend. And they had not reached the place of temporary safety, and he shot and killed his friend, which was one of the co-felons. And they said under the felony murder rule, who is he guilty of? Well, he's clearly guilty of the clerk or the guy that they robbed, right?
Right.
Is he guilty killing his friend too?
Yeah, but first degree, I mean,
Or like maybe they're charging the girlfriend for the act. And maybe that's what it was, because they weren't charging the guy who actually did the killing. So maybe they're charging the girlfriend. Is the girlfriend guilty of the because she didn't do any of the killings? Is she guilty of the guy, the drug dealer being killed? So okay, so here, let me make it clear. So we have D1, D2, G1, call her girlfriend, okay? So D1, so these two are boyfriend, girlfriend. So D1 kills dealer. Now don't forget, they're all together, they're all in this together. And then D1 finds out, well, maybe it's his girlfriend. So he finds out the D2 is sleeping with her, so he kills D2. Is she guilty of this and that? Am I making it clear? Am I making it clear at all?
No.
No?
no, she's
Okay.
not guilty.
So is she guilty of the dealer's death?
Yeah.
Yes.
Yes, killing by a co-felon. Is she guilty of the death of D2? No, because it's not. Because think about this. For felony murder, it has to be connected. It has to be within the scope of everything. This is not something that was part of the robbery. It had nothing to do with it. Even though they hadn't reached the place of temporary safety, one thing had nothing to do with the other. So it wouldn't be felony murder either one. Here it would just be intent to kill. There you go. I'd rather do it. Here's another thing they like to do too with concurrence. Which is a pretty easy question, but somehow you might get tripped up. So I want to kill my boss. And I go to a store, I buy equipment, and I know my boss isn't home. And I go inside the house, and I get in the house, and I set up the equipment that when he turns on the light or he walks in the door, it's going to blow up. So I leave it there at the house. As I'm driving away, like either a deer or something, or somehow my car loses control, and I smash an oncoming car and kill the driver, who happens to be my boss on the way home. Am I guilty of murder of the boss? Okay. So what do you think? Raise your hand, tell me what you think. And for anyone in the peanut gallery, yes, I call you guys the peanut gallery, the ones that are watching remotely. What do you guys think? Does everyone understand the example that I gave? So I want to kill my boss. I set up the equipment to blow up his house. When he gets there, as I'm driving home, as I'm driving away, I end up like accidentally, whatever, there a pothole or a deer or whatever, not my fault. Well, even if it was, maybe I'm even a little bit negligent. They made it seem like the driver wasn't negligent, which is the defendant, and I end up hitting the car that's coming the other way and killed the driver. Turns out it was my boss. Am I guilty of murder of my boss?
I think you're guilty under felony murder because you committed a burglary the moment you entered into the dwelling and.
Okay. All right, so he said guilty of felony murder. Interesting. Anybody have a yay or nay or any other theory, or what else do you think? Go ahead, Nicole.
I would say no, because it actually took place it's an accident that occurred while you were even though you had the intent to kill him, but I guess that's not the way you wanted to kill him. But I would say no. I may be wrong.
Okay, Olivia. Repeat the facts. So I go to my boss, break into my boss's house. I set up detonating equipment to have the house blow up when he gets home. As I'm driving away, I'm driving, 10 and 2, speed limit, everything great. Somehow something happens where my car loses control. I smash into the car coming the other way. Realize like I'm probably like miles away from the house, at least let's say a mile from the house or so. And then I'm smashing the driver, killing the driver to the other car. Happens to be my boss. Coincidentally.
You were talking about causation. whether or not it's foreseeable for somebody to go commit a crime and then on their way back, is it foreseeable for you to crash into somebody and kill someone?
So I'll answer it. So about the argument about the felony murder rule, this is no causal connection to the felony. One thing has nothing to do with the other. So it can't be felony murder. And what about my intent to kill? I intended to kill him and I killed him. No concurrence. No concurrence. So so could I be found guilty of attempted murder? Yes, but not actual murder. You might be able to get me for involuntary manslaughter if like, whatever, but what they were getting at was concurrence there. My intent did not align. It was just a freak accident. And think about it. If you let this is why I say stop like trying to memorize law, and if you just let it naturally, it makes like you're gonna hold me guilty of murder. Because think about it. By the same token, would I have been found guilty of murder if it wasn't my loss of the driver? No, clearly not. There's your answer. It was just an accident. But attempted murder, because I did try to kill him. So I did everything possible. Just didn't get it.
Would attempted murder or involuntary manslaughter be the lesser or greater offense? Like which one?
They'd be separate crimes because they're completely separate things.
Got it. So you could be.
If you attempted murder, the
convicted of
boss be involved. They'd be actually separate.
You could be convicted of both crimes then.
I guess you could because they're two separate acts. Yeah.
Okay.
Yeah. All right.
Jason, one more thing. So
Go ahead.
the distinction between credit card and just one is very good, one is not.
Yeah.
That's it.
Yeah. One's like. This is also subjective. This is more of an objective thing. Like it has to be extremely risky, and you have to be subjectively aware of that risk. I mean, that's almost never an idea because who the fuck's not aware? Could probably 90. Who's not aware of that? Who's not aware of firing a gun into a crowded room is likely going to hit someone? So I've never seen really that component, but they do make a subjective point out. It just has to be it's a matter of.
But if you drive like 10 miles over the speeding limit, that's probably negative.
Would you do that? Have you driven 10 miles over the speed limit? If I'm not going 40 miles over the speed limit, I'm not speeding in my opinion. Like, if you don't think I'm on 90 to 100 the whole way. And I'm just like, I'm not like driving recklessly, I'm just driving. That to me, like, have you ever tried going 65? Oh fuck. So I can't do that. I'm used to, I mean, even when there's a cop next to me, I'm still going 75. They don't pull me over. Go ahead. Question back there. Oh.
I was gonna ask one. Because I had trouble with this, I was like.
All right, so you don't have to speak up just so everyone else can hear you. I mean, I can hear. I mean, I'll repeat what you say if I. And by the way, for those of you who are watching on the chat or in the class, if you guys can hear something, let me know. Just actually immediately interrupt and say, "I'm sorry, I can't hear." This way, I can repeat to you what they're saying because I want you guys to get the same experience, or I can have them speak up or whatever the case is. Okay, so just let me know. Again, communicating with me is great. Don't feel bad about telling me anything. Like one student after class on I think Thursday or maybe Monday brought up a typo to me that was really, really small. And he's like, I didn't know if I should bring that to your attention. I'm like, yeah, absolutely. I don't care exactly. Because it was so small. It was one little letter that wasn't bold and italicized. And I was so happy that he caught it. So I'm like, I would never have seen that. And it makes my product better. And I like that. So that's why I ask you to do that. So you're not offending me. I'm asking, you know what I mean? Okay. So go.
But I was like, okay, I committed a crime, I robbed something.
All right, so she's thinking about she committed a crime and she robbed something. Okay, go ahead. You leave, you go home, you're distributing the money. Okay, so like giving out Christmas gifts. All right. All right, so she's with a co-conspirator now. She's kind of giving the whole her and Bert example. Go ahead.
I was just wondering.
When does the crime end? When you reach a place of temporary safety. So, oh yeah, the crime's over now. Like when you got to Chuck's house, crime's over. Okay. So what you guys are getting confused on, and I had this conversation with someone this week, was the MBE question where the person was still tied up. Yeah, and you might have done that one where the person was still tied up, and like the guy had already been arrested, and I think a day later, hours later, the person who was tied up in the kidnapping ended up dying. Logically, ask yourself: is that part of one chain of event? Is that all part of the same kidnapping? Yeah, there's no way to cut it off. Just because he had been arrested, that doesn't make it automatically over. Look, a lot of the times, they'll find the person and like, let's say there was a kidnapping. In the first, they'll ask them, is this person still alive? Let us know. Let us know. Where is she? You know, it's just she. You know, like, where is she? Like, and they found people alive, emaciated, like in stores, like just chained up. I've seen some really terrible shit, you know? But it's on my feed all day long. I love that stuff. It's so terrible though. If you ever see like what is something terrible they used to do to like in insane asylums back in like the 1700s, holy shit. Whew. They used to put you in this thing and spin you around fast. Because this doctor had this wild notion about like how that could cure mental illness. It didn't. We approached the fuck out of people. They were just really terrible. Oh, it was just so terrible. The stuff they used to do. I'm dunking me in cold water, oh, it's just terrible. Anyways, why I watched this stuff up. So, anyways, everyone good with that? Okay. Well, we'll do